I'm Sarah Clover, and this is the Agent of Change podcast, the series in which we look at anything and everything to do with the Agent of Change principle. In previous chapters, I have looked at the meaning of the Agent of Change principle, the policy process that sits behind it, and some of the background to it, where it's come from, what it all means, and some of the participants in the planning system that might want to get involved and use it, typically the decision maker in the planning process, whether that's a committee or whether that's an officer making a delegated decision, perhaps a planning inspector, and also the professional officers who need to be consulted about a planning application, typically environmental health officers, environmental protection officers, and of course the developer themselves who would be making the application and would need to take the principle into account, and the businesses that might be affected in the locality where the application is going to be. The subject, if you like, of the Agent of Change principle. Now, in this chapter, I wanted to look at another very practical topic, namely what any of those participants might be doing about the Agent of Change principle. What tools are there in the armoury for any of those decision makers to actually use to implement the principle in an action, and to see how to mediate the relationship between that incoming development and the businesses that are already in the locality. Now, this is a particularly interesting aspect of Agent of Change, and one that truly reflects its novelty and its recent emergence as an issue to contend with. Because Agent of Change is not law, because it is just policy, then effectively the decisions that can be made about it and the tools that can be used about it are as many and varied as the cases in which it crops up and the participants that get involved in it. In other words, there is no one right answer. There is no one particular source to go to for a definition or for an intervention that must be applied in any given situation. And to a large extent, that is what this podcast is all about, to try and collate some of the examples and the issues and the problems that arise on a case-by-case basis, that are arising relatively organically up and down the country as everybody gets to grips with what this policy actually means. Because there is no one intervention or solution that fits every situation, inevitably you get a wide range of solutions that different decision makers have applied. And some are more effective than others, some are better than others, and they all bear some consideration. For Agent of Change problems where new neighbours might be disturbed by noisy venues, of course, there might be a number of different things that the decision maker would want to think about. The answer at the moment is pretty much whatever participants say it is going to be. The first port of call is going to be the planning permission itself. That is the baseline for the control of the development that's going to be granted. And it's important always, not just to do with Agent of Change, it's always important to reflect within the planning permission and its conditions the need to harmonise that development with its location, with local businesses and local transport and local conditions on the ground and all of those things. And the conditions on the planning permission will always reflect that, the design of the building perhaps, the acoustic mitigation generally, the orientation of rooms, and all of those things are part and parcel of the required relationship between what is being built and what is already there, and that is standard stuff. There have, however, been many examples of planning permission conditions that are specifically oriented towards the Agent of Change issues and problems, rather than just general design issues. Some solutions built into conditions have attempted to head complaints off at the pass, and this is an interesting area to look at. For example, by trying to get a developer to require incoming residents not to complain. Now that's an interesting approach, and the way to pin that down has been approached in a number of different ways. For example, having conditions that incoming residents need to be informed, if not warned, about the noisy nature and character of the area into which they are moving. to have that sort of information in marketing material, perhaps to have it reflected even in occupancy, tenancy agreements, that kind of thing. It might be regarded as somewhat ambitious to get people to promise not to complain. And generally speaking, these conditions that have been seen so far don't attempt to go so far. It's really a requirement on the developer to pass on that information. Well, of course, the problem with that is that the condition is discharged as soon as the developer does exactly that and passes on the information. What the income resident then does with that information is really in their hands and the hands of fate. So in terms of reassurance for the businesses that might be affected, perhaps not so cast in stone as one would wish. So that is fraught with difficulty. There have also been examples of informatives that have been added to planning permissions. Now that perhaps is even less secure than trying to impose agent of change remedies by way of condition, because of course informatives are not conditions. They are, exactly as the title would suggest, purely to provide information. They are not enforceable. There has also been relatively recent High Court case law that indicates that if a topic is not suitable for a condition because it's not clear enough, it's not enforceable enough, then it would be inappropriate to try and turn that into an informative purely as an alternative to a condition. Informatives are not substitutes for conditions. Then we have a range of solutions that might loosely be grouped under the title Agent of Change Agreement. Now, although this is starting to emerge as a term of art, there is actually no such formal thing as an Agent of Change Agreement. There is no source or publication that recognises an Agent of Change Agreement. It is not a recognised entity in any meaningful way. It's more of a label that has sometimes been applied to a solution that has been used in a planning case. It really means no more than an agreement or a contract in effect, and it could be anything that the parties decide that it should be, and to that extent it has a similar feel to perhaps mediation. But it sits outside of the planning process. It's not built into the planning decision in any way. And the planning permission, the grant of the permission, is not overtly dependent upon any such agent of change agreement at all. Now, these agreements can go in either direction. They can either be something that the developer is going to do to the development. Sometimes it can be a promise or a contract that the developer is going to perform upon the noisy business itself, perhaps the music venue or the pub, something like that, and the developer agrees and promises to amend that building in some way, mitigate it, attenuate it. Perhaps we've seen examples of acoustic lobbies being built or additional glazing being installed. Sometimes the developer will literally perform those works, and sometimes they will pass over money for the business to be able to implement those steps for themselves, and that those sorts of things can be enshrined in an agreement or a contract so that everybody knows precisely what is going to happen. Sometimes the agreement comprises a relocation for the noisy business. So you can actually have a scenario in which the developer promises to take the business out of its unsuitable physical building and put it somewhere that is going to be more sound attenuated and that residents are not going to find quite so noisy and intrusive. It can sometimes be part and parcel of the new build development itself. We've seen examples of nightclubs, for example, being relocated into a mixed-use development, part of which is residential, part of which is something else, and it has a section, perhaps a basement or something, that has been specifically built to accommodate a nightclub and is suitably acoustically mitigated for that purpose, and that can also work. So you can clearly see that there's a very wide range of options available depending upon what is convenient and suitable for the parties, and also, of course, for the level of cooperation that is going on between the parties. These sorts of solutions are really only amenable to a friendly and cooperative relationship. Where that has broken down, you're far less likely to see these sorts of shake hands agreements springing up. Another similar solution or option is the Section 106 agreement. Now, these are obviously very common and familiar to us in the planning process, but they can be deployed to capture an agent of change remedy of some description. It raises issues of its own to get the solution into the Section 106 agreement, and the first hurdle or barrier that one would have to consider is who is going to be a party to that Section 106. Will the noise source, the noisy business, be a party to the Section 106 themselves, or will it be simply between the developer, landowner, whoever would normally need to be party to the 106, and the local authority, which is what might usually be seen? You wouldn't typically include a third party in a 106, although obviously it can be done. Now, if the noisy business is not going to be a party to the Section 106, then they really are in the hands of the parties, and perhaps particularly the local planning authority, to police and to enforce that Section 106, to make sure that the measures are delivered in due course, whether that's money payments or physical works or whatever else it might be. And of course, to have confidence in the local planning authority that they're not going to agree to amendments to that Section 106 further down the line. The business is also going to want to know whether any money payments are ring-fenced for the works that have been identified for the noise source for the business, or perhaps whether that money is simply going into a pot that the local authority is going to need to use for a number of different purposes, and perhaps once again, as we've discussed previously, the agent of change priority goes further down the list as other priorities take control. So that is it's certainly a potentially effective solution, but there are those issues with it. Another example of a solution that has emerged but has not yet been effectively deployed is attempts by the local authority to fix a position for the noise source whereby the noise that they are producing at the point in time that the planning permission is granted is recognised in some way as being acceptable in nuisance terms, in the sense of being an exercise of best practicable means by the noisy business, that they cannot reasonably produce any less noise than they currently do. Now, that is fraught with danger, as might immediately be apparent, because this takes us into a completely different regime, into the nuisance regime, which is mediated by the Environmental Protection Act 1990, and there are statutory duties in there. And the best practicable means defence is a statutory defence, and so it has certain parameters built into it that might make it very difficult to capture in a planning agreement of any description. And developing that idea a little bit more, we come then to perhaps one of the most controversial tools in the agent of change armoury, and that is a deed of easement, which shares some of the characteristics and the problems of the best practicable means approach. Now, first seen in 2014, deed of easement was an approach that was used in a development that was Eileen House, that was the original name, in Newington Causeway in Southwark, and they were building very close to the iconic club Ministry of Sound, who make and might be expected to make a certain amount of noise in the furtherance of their very famous operation. Now, the deed of easement solution is of such significance, and there's so much to say about it, that it will be the subject of a separate chapter on its own. But suffice to say, for the purposes of this overview of available agent of change remedies, that a deed of easement is a legal document. It comes from the same place, essentially, as a contract. It purports to be a legal grant of rights by one party, one landowner, to another, capable of being recognised as a land right, capable of being registered as such, and capable of being passed, the benefit of it and the burden of it being passed from one landowner, one title owner to another, whether that is a freeholder or a leaseholder or somebody who is taking title in that way. And the basic principle is that the developer grants an easement to the noise source to be able to continue to cause a certain level of noise, and usually that's measured as the level of noise that was being made at the time that the planning permission was being granted, that shall be deemed not to constitute a nuisance or to give rise to complaints. And the developer undertakes to let their development, the residential units, on to the tenants, subject to that deed, the easement, and the rights that arise. Now, it's fraught with difficulty because, again, what we're talking about is interfering with another regime, with the nuisance regime, which the local planning authority have to administer and enforce, and within which there are statutory rights and statutory duties. So the local planning authority are under particular requirements under the Act to take action in certain circumstances. Now, in the examples that have been seen so far, the local planning authority would not be a party to the deed of easement. And when it comes to applying such a deed in any of their steps or enforcement action, there are some immediate issues there. But I will leave that detailed consideration to another day. This is of enough interest to take up a section all on its own. But that's a broad overview and selection of the agent of change remedies that have been looked at and identified to date. No doubt there are some others as well, but that's just a preliminary consideration. And in future, we might take a look at some specific case studies that work through how one particular remedy or tool was used in a particular case and how effective or otherwise it was. But that is the chapter for today. Thank you very much indeed for watching. I'm Sarah Clover. I am from King's Chambers, and this is the Agent of Change podcast.